Okay, everybody, we're going to go ahead in this lecture talk a little bit about the court system. So, our court system is made up of two sides, right? So we have the state court system, which, in all actuality, will probably, have some type of experience within our lifetime. And then we'll have the federal court system, which basically deals with federal law. And we'll talk about things like jurisdiction and what might be some examples of federal law and all that stuff. And kind of, delineate between the two. And then also look at how they affect us here. So, the federal court system and the Supreme Court really derived their power from a case called Marbury versus Madison, which we've talked about earlier in this semester, right? Marbury sued um, for a commission that was supposed to be delivered. The main important part of this case is that the Supreme Court gave themselves the power to determine whether or not a law is constitutional, right? And I think that's probably one of the greatest powers that exist here in the United States, and establishes the concept of the Constitution being the supreme law of the land, and U.S. laws and state laws must be congruent with it. And remember that a federal law is always going to have precedent or have power over a state law. And in this concept of judicial review, Marbury versus Madison gives the Supreme Court the power to declare a law unconstitutional, right? So the first federal judicial review over state laws, constitutions, and court decisions are seldom questioned. We also can establish something called judicial nationalism in this instance. We have a court case called Martin versus Hunter's Lisi. This gave the court the power to review decisions by state courts as well. So state courts' decisions could be reviewed by the United States Supreme Court. McCullough versus Maryland, another interesting case that establishes kind of that right that the federal government can have on state governments and kind of the influence they can have. We talked about the necessary and proper clause in the past, and this is a lot of where some of this decision came out of. McCullough versus Maryland, as we discussed during our federalism part here, they established the fact that, federal authority is going to outweigh state authority. So if we talk about the making of a Supreme Court justice, usually these justices are going to be, from the socially prominent and influential upper class families. Our current court is a lot more diverse than the courts in the past, and more than 2/3 of justices who have served have attended Ivy League schools. This process, where we have the President of the United States nominate a Supreme Court justice, is a very, very political process. And this has been the case since the 1980s. And more so also in the 1990s with the kind of the hearing to confirm Clarence Thomas, who is on the court currently. There were some allegations of sexual harassment by a subordinate in the area that he used to work, and during the confirmation hearing, we heard a lot of kind of some of that stuff that existed during maybe the relationship and some of the actions that happened in his office with regards to Ms. Anita Hill, who accused him of sexual harassment. There's a lot of documentation out there, and there's a lot of books written about it. So if you want to learn more about it, go ahead and take maybe a quick Google search, and it'll come up and inform you a bit of what happened during that hearing. Here's the current court. As you can see, we have six justices that were nominated by Republican presidents and 3 justices that were nominated by Democratic presidents, and Amy Coney Barrett is the most recent. So you can see that right now we currently don't really have a balanced court. It's kind of swinging over to the conservative side, even though ideology is not supposed to play a part in decisions here. Obama had the nominations of Sonia Sotomayor and Elena Kagan. Both were confirmed. Trump nominated and had Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett confirmed by a bipartisan Senate. The Brett Kavanaugh hearing was a very well publicized confirmation hearing, and made fun on of TV. Some of his temperament, maybe some of the allegations of his over drinking at times. Before the Trump presidency, the criteria to confirm a Supreme Court justice was 60. So you need 60 senators in the U.S. Senate, 60 out of 100, to vote in the affirmative to confirm a Supreme Court justice. Knowing that Neil Gorsuch, who was Trump's first appointee for the Supreme Court, knowing that he probably wasn't going to be able to get 60 votes, Mitch McConnell, who was the Senate Majority Leader at the time, simply changed the rule. So instead of 60 now for a presidential nominee, you only need 51, and this is what is called the nuclear option. And the criteria wasn't in the Constitution, so it's basically a Senate rule, so the Senate could tweak it if they had enough power to do so. Nominees are regularly, asked questions, and sometimes they might keep their stances ambiguous in order to not to offend anybody. But sometimes if they might potentially give an opinion that is really specific, they might looked at that they're not totally partial, or they're not able to maybe just look at the legalities of the law without ideology coming into play. So remember, we have a federal court system as well as the state court system. Trial courts of the federal system have over 600 judges, and these judges are placed on the bench and are able to serve up for life. Right? They hear criminal cases that are prosecuted by the U.S. Department of Justice, as well as civil cases. Some criminal cases might be things like kidnapping and taking somebody across state lines, the murdering of a federal official, some type of crime in a federal building, maybe robbing a bank, since money is protected by the Fed, and maybe transporting drugs or people across the border. That's another thing that can cause you to end up in federal court. So, they use grand juries and regular juries. We're really not going to get into depth about, maybe the functionalities of the courts as far as trials. But, grand juries and juries are there to either indict a person. A grand jury is used to bring out an indictment against the person. Basic citizens that come together and make decisions about whether or not to press charges against somebody or indict somebody. And juries, as we all know, are instances where you can have people maybe judge you in a case, or listen to your case and make a decision about your case, either on the criminal side or the civil side. Remember, criminal, we all know what that is. Civil, if you have a disagreement per the 7th Amendment, we can go and sue somebody. The next level up above the federal court system, above the district courts, is the Circuit Court of Appeals. You can't just appeal a case because you lost. You have to appeal a case on the basis that there was some type of violation of the Constitution that happened in your case. So they don't hold trials, or they don't accept new evidence. They only consider whether or not the trial court, in this case the district court, was acting within the framework of the Constitution, right? They have little discretion in hearing appeals, and nearly 100 circuit court judges throughout the country usually serve on 3-judge panels, and most of our cases will end at this level. So you could see here is the federal court system. We have these courts that are considered to be the district courts, right? And there's 94 of them in our 50 states. They hear criminal cases as well as civil cases. We also have bankruptcy court, territorial court, the federal courts of claims. This is where you'll sue if you have a grievance that qualifies to be heard in federal court. We'll talk a little bit about that in a minute. The FISA court, and a bunch of tax courts as well. And at the next level is the U.S. Court of Appeals, and there's 12, and we'll look at these in a minute. And then we have the Supreme Court at the very top. And then keep an eye on this. We also have state courts on the left. We'll talk a little bit about state courts in a minute. So here are our United States Court of Appeals. As you could tell, it's divided up into 12 districts, including the D.C. Circuit, Federal Circuit Court, and the Supreme Court. So we have kind of geographical boundaries of appellate courts here in the United States. On the West Coast, here in California, we're a part of the Ninth Circuit. So if there is a federal appeal that we have from the district court here in San Diego, we would elevate it to the Ninth Circuit U.S. Court of Appeals. So if we look at the Supreme Court is going to be the final interpreter of all matters regarding the U.S. Constitution, federal laws, as well as treaties. They have what's called discretionary review, meaning they're the ones that determine whether or not they want to hear a case. So there's something called the rule of four, right? So if 4 Supreme Court justices agree to hear a case, then it'll be reviewed. And we'll talk a little bit more about the processes in a minute. And the session for the court runs from October through June. All right, so, you get July and August, September off. Federal court's jurisdictions extend to certain types of matters here. And when we use the word jurisdiction, try to maybe kind of interchange it with maybe responsibility. Federal court jurisdictions extend to cases that have, where questions that exist about the Constitution, exist about federal laws or treaties, any type of case that might involve an ambassador, a public minister, or counsel, or things that might happen on the ocean or the seas, where the U.S. government is a party. So if somebody's going to sue the U.S. government, then it'll be heard in federal court. Between 2 or more states, between a state and a citizen of another state, between citizens of different states, and between a state or a citizen and foreign government, a citizen of another nation. So you can see the jurisdiction is pretty wide in here, but it's also very specific to certain things that the federal court system is responsible for. You can directly appeal a case from a state Supreme Court to the United States Supreme Court. Federal courts usually do not interfere with state court cases. Parties to cases in state courts must go through the entire state court system before federal court will hear their appeals. So, for instance, we'll talk about the nuances of the state court system in a minute. But if we go through the state court system and go up and not get any relief through there, we can appeal a case directly to the Supreme Court without having to restart in federal court. Usually, federal court caseloads are going to be less than state courts. Most of your cases are going to happen in the state court side, but federal courts do have a lot of traffic in it, right? So when we talk about it and talk about some of the things that come out of the prosecution of crimes, federal crimes generally center on offenses that were committed against the U.S. or its property. We talked a little bit about that. Were committed against the U.S. government official or employees while on duty. Something that may cross state lines. Interfering with interstate commerce is a violation of federal law. And any type of crimes that might occur on federal territories or over on the seas. And like I said, federal court judges hold their seats until they resign, die, or are removed from office. This includes district court judges, appellate judges, and Supreme Court justices. So on the federal side, judges are on the bench for life. Now, there's some kind of, different schools of thought on how people should, in a sense, act as a Supreme Court justice. Should someone be a judicial activist? Should a court look for cases to rule on? Or should justices practice judicial restraint, meaning they wait for cases to come to them? Right? And when we talk about the rules of the restraint, there's kind of some unwritten rules that the Supreme Court will follow. They won't advise the president or Congress on constitutional questions. They won't decide cases that are hypothetical. They won't focus on something that is outside of the scope of what the case is. and they won't pass up a constitutional question if some other grounds exist upon which it may dispose of this case. This might be something known as precedent, which we'll talk about in a little bit. They'll try to interpret the laws to give it a constitutional meaning. All your remedies have to be exhausted in lower court and in state courts before the Supreme Court will accept review. Occasionally they can fast track, but that doesn't happen that often. And they will only confine this decision to the particular section of the law that is specifically unconstitutional, right? Something called stare decisis. And stare decisis is Latin for let the decision stand, right? It means that if the issue has already been decided in an earlier case, that the decision stands and has precedence. So hypothetically, even though I'm not quite sure this will happen, hypothetically, for those of you that might be concerned with women reproductive rights, Roe versus Wade establishes precedent for women's reproductive rights. Now, at times, judicial activists might be willing to discard precedents and overlook that and make a decision that overrides. One thing that immediately comes to mind is the case of Plessy versus Ferguson. Plessy versus Ferguson was a civil rights. Like I said, there was a court case called Plessy versus Ferguson that determined that you could separate facilities, but they had to be equal. That was overturned by the decision in Brown versus Board of Education, which found that all these facilities were inherently unequal, therefore it was unconstitutional. So there are incidents where precedents might be overridden. Now, there's also a couple of schools of thought with regards to how the Supreme Court justices should look at Supreme Court cases. Should they use the concept of original intent, meaning that takes the values of the founders as expressed in the text and applies them to current conditions? So, in a sense, trying to apply the law as clearly as possible and as clearly as they're able to, with regards to their interpretation of the Constitution, maybe following the Constitution word for word. Now, there's also kind of that, wisdom type thought where you can kind of analyze and look at the constitutionality of laws by maybe applying everyday needs or everyday kind of culture type instances. We've also become very, very reliant on courts. That's generally how we solve our problems here. We take people to court. Politicians seem to abandon their charge to govern when controversy will arise, leaving the courts to decide constitutionalities. We have a lot of congestion in court. We have more than 1 million lawyers practicing. Over 250,000 cases begin in federal court each year. About 10% go to trial. More than 50,000 cases are appealed. The Supreme Court receives about 8,000 appeals each year, but they only take about 200 cases. And, some of the questions that are raised, come out of the fact that some people think that the judicial elite is increasing their powers, that we have our court system overburdened, and at times we have injustices, which we all see. There might be instances of plea bargaining. Plea bargaining is generally used both in federal court and state court. If you're charged with a crime, it might benefit you to plead guilty to a lesser crime, avoid trial, avoid, the time and cost of trial. 90% of cases are plea bargain. So that's a really interesting thing to look at. And it's more likely to be made by someone who is accused who cannot maybe afford a good attorney and accepts a court-appointed attorney who already has a large caseload. Go ahead and look over this. So some famous Supreme Court cases include Plessy versus Ferguson, which establishes that separate but equal doctrine. Brown versus Board of Education, which eliminated Plessy and desegregated public schools. Griswold versus Connecticut, which will be discussed in another lecture we have here, as well as Roe versus Wade. Matt versus Ohio, Gideon versus Wainwright, and Miranda versus Arizona. We're going to talk about these in the civil rights portion of this class, and we'll talk a little bit more in detail about these. So when we look at the Supreme Court of the United States, they're going to be the final interpreter of all matters regarding the U.S. Constitution, federal laws, and treaties. Like I said before, they determine whether or not they're going to accept a case. If they accept a case, they order something called a writ of certiorari. A writ is an order of a higher court to a lower court to send all documents that they have about that case to the higher court so they can review and make their decision. And there's something, like I said, called the Rule of Four. 4 of the 9 justices must vote to accept a case. And we talked about the session times. So if we want to appeal a case to the Supreme Court, the petitioner has a certain amount of time to write a brief, not to exceed 50 pages, putting forth their legal case concerning the issue on which the court granted review. After the petitioner has a brief, the other party, known as the respondent, is given a certain amount of time to file a respondent brief, and this brief can't exceed 50 pages either. So just think about it. 50 pages might sound intimidating, 50 pages might sound a lot, but when you're dealing with a complicated Supreme Court issue or a complicated constitution issue, that 50 pages might go pretty quick. If it is not involved in the case, the United States government, who could be represented by somebody called the Solicitor General, can file a brief on behalf of the government showing the government's take on that case. If a group or maybe an interest group or some demographic group is affected by this, something called an amicus curiae can be filed as well. This is Latin for friend of the court, meaning that if a group is affected by this, they can be asked to write a brief, and they can provide their argument and recommendations on how the case should be decided. The Solicitor General usually argues cases in which the U.S. government is a party. During oral arguments, each side is going to have 30 minutes to present its case. Again, this might seem a little bit daunting, but remember, you have to be accurate, you have to be brief, you have to use that 30 minutes well. The petitioner goes first, then the respondent. If the petitioner reserves time for rebuttal, the petitioner is always going to speak last. When we have oral arguments concluded, the justices get together. The justices will vote, and if there's a non-unanimous decision, generally you're going to have a dissenting opinion as well as a majority opinion. Majority opinion are going to be written by the majority group who voted in the majority. Simple to say, right? So the most senior judge in the majority is, or the highest ranking judge in some instances, because they also can be ranked by, the Chief Justice, who is John Roberts currently. If he is in the majority, he will assign a justice who votes within the majority to pen the majority opinion. If the Chief Justice is in the dissent, then whoever the most senior judge or senior justice in the majority will direct the justice to write the majority opinion. So we could see that. And the most senior justice in the dissent can assign a dissenting justice to write the dissenting opinion. Now, there's also something called a concurring opinion, right? If a justice agrees with the outcome of the case, but for a different rationale or a different maybe interpretation of the Constitution, they can write something called a concurring opinion. Any justice may write a separate dissenting opinion of their own as well. Sometimes these opinions can be very voluminous. They can be large in pages. But sometimes you can get a really, really good understanding of what the court and the court system is trying to accomplish in their legal rationale. So we talked a little bit about the majority opinion, the concurring opinion, and the dissenting opinion. So you have those definitions right there. We talked about precedent, that stare decisis. And now let's kind of look at the path to the Supreme Court. And I always think this is kind of interesting. We're going to use the case of Windsor, United States versus Windsor. And this is a case that looked at what was defined as a marriage and what the federal interpretation of marriage and spouse was to be, and when we try to apply that to opposite sex unions. Before, we used to have a law in the 90s called the Defense of Marriage Act. And what the Defense of Marriage Act did was it defined marriage to be a union between a man and a woman. There's certain advantages to be married, and we'll look at that. Section 3, like I said, Section 3 of DOMA put forth this definition. Therefore, when people sued, they were alleging that their constitutional rights were being violated, and that DOMA was unconstitutional under the Due Process Clause of the Fifth Amendment. Edith Windsor and Thea Spire were a same-sex couple that were married in Toronto, Canada, but they lived in New York. In 2008, New York recognized their marriage following a court decision. Spire died in 2009, leaving her entire estate to Windsor. And you just probably, you're going to see how much her tax was in a minute, but I'll tell you right now, Spire was an investor in IBM at its startup, so you can imagine that she probably had a pretty good bank account as a result of that. Windsor sought to claim the federal estate tax exemption for surviving spouses. She was barred from doing so because Section 3 of DOMA, which provided that the term spouse only applied to marriages between a man and a woman. So remember, at this time, the same-sex marriage was not being recognized by the federal law. The IRS found that the exemptions did not apply to same-sex marriage. They denied Windsor's claims, and they compelled her to pay $363,000 in estate taxes. If they were an opposite-sex married couple, she wouldn't have had to pay that $363,000 tax. Windsor filed in November of 2010, filed a lawsuit against the federal government in the District Court of New York, the Southern District Court of New York, alleging that there was differential treatment compared to other similarly situated couples without justification. Barbara Jones, who is a federal court judge, ruled that Section 3 of DOMA was unconstitutional under the Due Process Clause of the 14th Amendment and ordered the federal government to issue the tax refund, including interest. It was elevated to the U.S. Second Circuit Court of Appeals. In a 2-1 decision, they agreed with Judge Jones. The bipartisan legal advisory group, who was in favor of DOMA, appealed to the U.S. Court of Appeals for the Second Circuit. And like we said, they lost, and then they asked the Supreme Court to review. The Supreme Court accepted the case and affirmed that the lower court's decision that DOMA violated the 14th Amendment's Equal Protection Clause. And if we look at some of the rationale of what the justices were kind of being guided on with regards to maybe some of the benefits that might exist out of being married, like, you can pay less in taxes, you have protections with bankruptcy. Something that's also important might be something like an advance directive or a do not resuscitate order. There was a really, really good case made that same-sex couples were not afforded the same rights as opposite-sex couples. So we went in that. Basically, in the dissenting opinion, Justice Antonin Scalia, who was one of the more conservative justices before he passed, he basically felt that the Supreme Court did not have the jurisdiction to invalidate democratically adopted legislation that was passed. So we look at the path. We have the federal district court. This is where it started. Then it was appealed to the Second District Court of Appeals, and then eventually to the U.S. Supreme Court. With state cases, it'll go from trial courts, then to the California Court of Appeals, then the California Supreme Court. Remember, they only deal with California law, right? And if the California Supreme Court decisions need be, they can be directly appealed to the United States Supreme Court. Remember, they do not have to start over in federal court, but they do have to have all remedies exhausted before they can apply directly to the Supreme Court. Now, one thing about state courts, if you look at here are state court systems. Go ahead and click on the link. We'll have trial courts, We'll also have a District Court of Appeals here in California, and then we have the California Supreme Court. California Superior Court judges, we're going to maybe have to deal with them. If you really want to be, know something and be honest, is we're all going to have an experience with the court system within our lifetime. And I think at the very minimum, we're all going to have to deal with traffic court at a time. Traffic court is a part of the California Superior Court system. The judges that hear cases, whether it be in criminal cases or civil cases or small claims cases, they're all going to be heard by state judges. And these state judges are individuals that have to run for re-election or try to take the office of another judge through an election. So what will happen is if a judge position is open, the governor can appoint a judge to fill that, and then that judge has to run for re-election. If there is a judge that has to run for re-election, they can also be ran against. So another attorney can come in and run against them. We have the justices of the California Supreme Court and California Appeals Courts are first appointed by the governor. However, at the very next general election cycle, they must be confirmed by the voters. So it could be a political position, right? Usually it's their 12-year terms before coming up for election. And justices that appear on the ballot uncontested, which means no voters only have two options. They have to have at least one vote. And if you're pretty smart, you'll vote for yourself, right? Talked about the trial court. We have criminal courts, which you can have a jury or a judge. The standard to convict somebody under a trial court is beyond a reasonable doubt, meaning that there can't be 1% doubt in, the judgment that somebody is not guilty. So if there is a 1% doubt, then you have a instance where that person is to be found not guilty. Civil cases can be through a judge or a jury. They rely on something called preponderance of the evidence, something that's more likely than not. Especially in civil cases, you can maybe assign blame percentage-wise. So say, for instance, I sue McDonald's and I win $1 million, but the jury or the judge finds that I'm at least 10% at fault to my grievance, I'll only get 90% of the award. And you don't have to have that a unanimous jury like it is in criminal court. You can have it really depends on the size of the jury, but I think at most instances, it's more than 50%, preponderance of the evidence. We have small claims courts. These are, kind of your Judge Judy type courts where we have disputes that are less than 10,000 heard. You don't need a lawyer. The person who files a claim is called a plaintiff, and they go against the defendant. Then we have our Court of Appeals you can look at. And then we have our California Supreme Court, which has 7 justices as opposed to the United States Supreme Court 9. They have about 7,900 cases a year with about 85 cases heard. And if you look at this, you're going to see, and you click on this link, you're going to see that generally these justices are going to be very diverse. Okay, so that's our court system. Thank you, and we'll see you soon.